I'm pleased to welcome Jerome Buting here to talk this evening about his new book, Illusion of Justice: Inside Making a Murderer and America's Broken System. In theory, a defendant in the U.S. court of law is presumed innocent until proven guilty. But in practice, the assumption is often just the opposite, that the accused is guilty. This is just one flaw in the criminal justice system, and Buting, a criminal defense lawyer for more than 4 decades, reports on many more. Drawing from his early career as a public defender and his later work as defense attorney for Steven Avery, subject of the Netflix production Making a Murderer, Buting combines reportage, reflection, and critical commentary for an urgent call to action on reforming the American legal system. A review in Kirkus states, Buting commands attention with his account of Steven Avery's trial. He uses his expertise to make a convincing case, a compelling portrait of the mechanisms of building a murder defense. This is a fantastic look behind the scenes of the U.S. justice system. Buting is joined in conversation tonight with Carrie Johnson. She's a former Washington Post and Legal Times reporter and now works as NPR's justice correspondent, covering a wide variety of stories about justice issues, law enforcement, and legal affairs for NPR's flagship programs, Morning Edition, and All Things Considered. So please join me in welcoming Jerome Buting and Carrie Johnson to Politics and Prose.
Thank you so much. For those of you who haven't read Jerry's book yet, you're really in for a treat. We hope to give you a bit of a taste tonight.
It's not quite more than 4 decades, I will say. It's a little less than 4 decades as a lawyer.
About 35 years?
About 35, yes.
Okay. So, Jerry, this is not exactly the kind of professional choice people make who want to feel overly confident and on top all the time. Why did you dedicate your life to this?
Well, I've often asked myself that in the middle of a trial, a long trial. But I've always felt like the underdog need a voice, and so I've tried to be the champion for the underdog, and this is the way that I chose to do it.
And can you talk a little bit about? It's one thing to go out and defend a corporate executive, and it's another thing to go out and defend somebody who doesn't have enough money in their bank account to pay you, so you have to be paid by state funds, federal funds. Why target that kind of client?
That's the only kind of law I ever wanted to do, was to defend the individual person. I think actually I've got some friends of mine here who were public defenders with me at the very beginning of my career, and I just always wanted to be able to, first of all, work with individuals who needed a voice, who oftentimes didn't have the education or the skills to be able to express themselves, and yet were as deserving of a defense as a big corporation or somebody that's got a lot of money and can afford to defend themselves. And so I was drawn, I think, initially to, even though I didn't grow up poor, I grew up middle class and white, obviously, but I could see that there was a real need for people who don't have the kinds of blessings that I had in my life and advantages that I had in my life. And so I was drawn to try and defend those kinds of people because they're just as deserving as somebody who's got a lot of money or some corporation that, to have a good and as good a defense as they possibly can afford.
So in your book, you talk about the notion that for many of these people, the deck is stacked against them in the justice system. They don't get nothing is taken for granted. In fact, the opposite is the case, that these people are often presumed guilty before somebody like you can try to convince a jury that they're innocent. Can you talk a little bit about the fighting spirit, the importance of the adversarial system here and in your life?
Sure. We were founded on the principle. This goes back way back before the founding of our republic. The idea that it's it's better to, let 10 guilty people go free or men go free than to convict one innocent person. And I have a quote from John Adams that it was part of his closing argument, actually, that's been preserved when he was defending the British, who massacred a number of colonists in Massachusetts, 1765 or so. And he points out something that goes even probably at least 100 years before that, which is that the reason that's important is because crimes and guilt are so common, we can't possibly prosecute everything that goes on. But if we start to convict the innocent, and in some states, as was the case back then, even execute them, then everything that's the foundation of society can fall apart. Because if you're innocent and you think, well, even my being innocent isn't enough to prevent me from being imprisoned or to be executed even, then why should I obey the law in the first place? What kind of respect for the law can you have with that kind of attitude? And unfortunately, in this day and age, it's really flipped the other way around. Partly because of fear, partly because of a deliberate effort to scare people. But if you ask the ordinary person on the street, particularly if it has anything to do with potential of terrorism, and you say, would you rather that a few people go to prison who are innocent, or that somebody who's guilty go free, or that 10 who are guilty go free? And we need to get away from that because it's dangerous, and I think it's part of the reason why in a lot of communities in this country we have a disrespect for the law, and a increasing disrespect for the police as well. And it's all kind of, I think, goes into the soup of how they see themselves and their communities treated in the law.
The notion of community enfranchisement and buy-in is part of the conversation now more than ever. But as a person who spent his life in the justice system and who actually met his spouse in the public defender's office, you worked your tail off as a public defender. And you made a difference in several hundred lives, if not thousands, right? Can you talk a little bit about one of your early cases in which you found a flaw in the system?
Oh boy, there's a lot of them. There's one that I can talk about that's in the book.
Yes.
That where the one with the expert.
Yes.
Okay. There was one actually, and the way I got to know my future spouse really well, we started together as public defenders the very same day, right out of law school, and we became good friends, and we started trying cases together. But we had this one case where involving it was a drunk driving case involving breathalyzers, which were the machines used back then, and people often say, well, I only had 2 beers, and the machine's got to be wrong. But this particular client, it was way over the limit. It was like 0.20 or something, and he didn't fit any of the other symptoms of somebody who was intoxicated, and claimed he wasn't. So I started doing some research on it and discovered that the company that manufactured these devices, Smith & Wesson, had learned that there were flaws in their machines, that these things were designed back in the 40s and 50s, and they really looked like something out of a 1950s sci-fi movie with knobs and needles, and this was 1980s already. And it turns out that they had designed in no radio frequency shielding, radio frequency interference shielding. And as technology evolved, every police officer had their own little, walkie-talkie and their mobile units in there while they were working on them. And the manufacturer knew it, and they did tests, and you could see that when they got near, the needle would start going, and it was always up. It would go high. And so I said, this is wrong. We got to challenge this. And I needed somebody who was an expert on that, and I looked around, and it turns out I went to a library and tried to learn something about radio frequency interference that I really knew nothing about.
You're the child of scientists, though, right?
I am
Yeah.
the child
Okay.
of two scientists, organic chemists, and so I kind of taught myself enough about it and discovered that there was in Milwaukee, living there, this world-famous scientist, expert on radio frequency interference. In fact, he was a former Nazi scientist who was captured by the Americans at the end of the war, much like Werner von Braun, who was the head of NASA and helped us land a man on the moon. And I sent this off to him, and he looked at it, and he, I called him a few days later. He's like, I can't do the accent, but this is too stupid for me. This is too stupid for me. And I said, yeah, but Dr. Schlicka, people are going to jail because of this.
Yeah.
And finally, he's like, well, that can't be. Surely they're not using this junk. I said, yes, they are, all over the country. So we challenged it. We had this whole series of hearings that lasted about, 6 or 9 months. And I worked with Kathy very closely on that and got to know her very well. And so that was kind of a good way as one example. We ended up, there was like 900 cases got thrown out because of these defects. So
900 cases.
yeah.
But there's a point in your book at which you kind of have to sit down and have a talk with yourself about the life you chose and how you're going about your business. You want to read a little section?
Sure. I think I will go up here since I don't have time. So the little preface to this, I'll say, is that as a criminal defense lawyer or public defender, most of my friends would often ask me, how do you defend those people that are guilty? How do you do that? And I tell this story because this is really the best answer I can think of. One day I came back to the office in a foul mood. How was your day? Someone asked. Well, first of all, I ran 20 to 25 felony cases through intake, I said, with a sheaf of case forms in hand. It sucked. And then there's this guy with this ridiculous story. Now, at intake, I'd normally sniff around for some cases that I could tell would result in a reasonably quick plea bargain. Technically, the only real issue at the intake sessions was bail. But I'd quickly scan the complaint, and I'd ask the client if it was true. That way I'd know if it was likely to plead out, meaning that it would count toward my quota of cases I had to do, but that I would not have to lug it around for months. The guy with the ridiculous story had been arrested for a burglary in an apartment house. Witnesses identified him as having been in the building at the time of the break-in. He was not a stranger in the neighborhood. He managed a building across the street. And yet there he was, caught red-handed behind the locked doors of a place where he was not supposed to be. That was the account in the sworn complaint by the police officer. My client, on the other hand, gave me some cock-and-bull story about having to see somebody in the building, which, according to the criminal complaint, was not backed up by the officer's own investigation. So he says he's innocent, I told my colleagues. He's not going to take a plea. There's going to be a fight. It'll have to go to trial. And he's obviously as guilty as sin. Kathy, my future wife, spoke up quietly and said, I'll take the case. Fine, I said. Knock yourself out. Well, the upshot was that an investigator sent out by Kathy found out the man's story was 100% true. He had a legitimate reason for being in the building, and he was unequivocally innocent. The case wasn't plea bargained. It was dismissed outright. It was a good result for this man and a sobering one for me. What kind of lawyer was I becoming if I judged people in the first 5 minutes of meeting them? The hard truth is that this happens every day all over the country. Public defenders or other criminal defense attorneys under immense pressures that are a direct result of the lack of resources are prejudging guilt and innocence when they shouldn't. This episode made me realize that I could no longer be the lawyer I wanted to be under the constant weight of too many cases and too few resources. It was time for me to leave the public defender's office. And I did. And I set up a practice, and one of the things that we made a point of doing is to limit the number of cases we take so that I wouldn't have to. We were at a point, I think Kathy might have still been in the office back then, but we had to open 15 new felonies a month, whether we closed any of them. And there was no case waiting back then. You'd have to, a guy who breaks into his neighbor's garage and steals a bike, who's going to go on, get probation almost certainly, counted the same as a Avery case that would be 6 weeks in trial. And so you would be forced to make these kinds of snap judgments. You couldn't take 15 new Avery cases every month. It was impossible. You had to take some easy ones. And so those are some of the shortcuts. But the lesson of it is that a defense lawyer isn't supposed to make those decisions. That's up to a court, and certainly not with snap judgments. And you see that in Making a Murderer when you see Brendan's defense team, that despite the fact that his client was telling him, I'm not guilty, I didn't do this. Yeah, but you confessed. We got to work a deal. We got to roll you over. You know, that was the whole focus of his defense all along. And unfortunately, that's very common.
So, Jerry, despite this effort on your behalf to take fewer cases, devote more time to them, some of the problems you identified haven't gone away. In fact, maybe they've gotten worse. You made, what, $9 an hour on the Avery case?
Well, that's what Dean figured out. I kept, for a while I was keeping track of my hours, but after 6 months before the trial, it was gone. All the money that we'd been paid at my usual hourly rate. So, you know, but you don't just take a case because of money. That's not the only motivating thing. But obviously, you can't always take cases where you're making $9 an hour, or you can't make a living. You can't pay your staff and your bills. And but the sad thing is that there are lawyers, including the lawyer in Brendan's case. All of the lawyers, he had several, they are being paid, and were being paid 10 years ago, and are still being paid today $40 an hour, out of which they're supposed to pay their staff, their rent, utilities.
Phone bill, yeah.
And the average, I think the national average for overhead for those kinds of things, before the lawyer makes any money, is somewhere around $60 an hour. And when I started at the public defender's office in Wisconsin in 1981, they were paid $45 an hour. So it's gone down. And as a result, you can see the kind of quality you get. I mean, you can't get a plumber to come over for 5 minutes for less than $100. And yet we expect to pay lawyers to defend people who, you know, could go away for the rest of their life in prison, that little amount of money. And you know, so I can't say that the kinds of pressures have really gotten any better in my career, unfortunately.
So you came to hear about and learn about Steve Avery because you were appointed on a state commission to look at what happened to him and what went wrong in his first case, and then you came to defend him after his arrest.
Yeah, that was just a quirk. You know, I had various leadership positions in criminal law and the state bar and whatnot. And after his exoneration, there was a legislator who decided to do a task force and say, well, look, 18 years is a long time. At the time, that was the biggest, longest period of wrongful incarceration of any case in Wisconsin. And the idea was, well, let's see what went wrong in this case, and can we make reforms that are going to avoid it happening to somebody else. And so we had this series of hearings, and Steven Avery came to one of them. In fact, the first time, maybe the only time, I don't know, that he met with the victim in his 1985 wrongful conviction was in this hearing room. And there were tears on both sides, and hugs, and it was a very moving moment. And then after he was charged with this homicide, his civil rights lawyer, because then after he got out, he hired a lawyer to look at why he was convicted, and they found that there was some deliberate misconduct. Yeah. And so he had this lawsuit going, and then once he got charged with the homicide, his civil rights lawyers gave him my name and Dean Strang's name and some others. But one interesting thing, as long as we're talking about this commission, even though there was no confession in Steven Avery's 1985 case, he'd always maintained his innocence, he'd never admitted it. As long as we had this commission looking at reforms, one of the big reforms that I had been fighting for years was to try and get mandatory recorded interrogations. For at least the last 15 or 20 years of my career up to that point, I don't know how many times I had clients say, "I never said that, they're lying," you know, and the police would say, "Well, yes, he did," and you know, they would fill out. Sometimes they would not even have him sign the form, but it would be a battle of who do you believe, the police or the defendant, and the defendants almost always lost. And so I really pushed to get the commission to look at the idea of making it mandatory that we record interrogations from beginning to end without any breaks in the tapes, so they can't stop and start it whenever they want. And it passed and became law just 6 months before the Brendan Dassey interrogation.
And that was critical to unraveling.
Huge. You can think, you know, if there had been no videotape recording of the Brendan Dassey interrogation, the detectives would have come into court and they would have testified just the way Ken Kratz did in his press conference, in which he made it seem like this was a kid who was overburdened with guilt and came out with this narrative, coherent story about this horrible, brutal murder, rape, and torture. When instead, when we actually look at the tape, we see something very different. We see questions being fed to him, facts being fed to him, and you know, almost, I don't think he said a coherent sentence the whole time. It's like one or two words at a time, and all the guessing that's going on. So it ultimately didn't help in the verdict in his case, in part because his jury didn't see as much as you saw if you watched Making a Murderer. His lawyers, for some inexplicable reason, agreed to cut the tape that was being played back to the jury before the last 15 minutes, before his mother comes in, the first contact he has with somebody other than police. And when he then is immediately recanting and saying, "They got to my head, Mom," his own jury never even heard that.
Which is unbelievable. And you point out that even though he's had some kind of intermediate legal victory, things are not over for him. Things are still very much a question.
They are very much still in doubt, because he did get the federal judge. The way it works is that you have, once your appeals through the state court system are done, you can go into federal court by filing a writ of habeas corpus, which is an ancient writ, goes back 500 years or so, although it's been made much more difficult in the last 20 years or so. But I knew from the beginning, in this case and some other cases that I've handled, that no state judge was ever going to grant relief to Brendan or Steven, because they're elected. And the case was way too controversial, way too much publicity, and elected judges, particularly in a small county. Think about all the judicial elections you may have seen. It's always, Sheriff so-and-so supports me, and police chief this, and it's all law enforcement endorsements. So if a judge who's elected and wants law enforcement to support him in an election throws out evidence or rules that the police coerced a confession, in a big case, they're going to not only not support him, they're going to get another candidate to run against him or her. And so I knew that there would really not be any relief until I got to federal court, where they're more insulated because they're appointed for life. And so a federal judge did reverse his conviction. He looked at the whole case and found that the confession was coerced and involuntary and unreliable. But the state is appealing that. And it's in the Seventh Circuit Court of Appeals right now. They just had oral arguments on Valentine's Day. So it's going to be many months yet before we know the result. But you know, you can't read the tea leaves too much from the kinds of questions that judges ask at oral arguments. It's online if anybody wants to ever listen to it, for the Seventh Circuit Court of Appeals website. But I think the argument went well. Brendan has two very good lawyers right now from the Northwestern Center for Wrongful Conviction of Youth, and they did a really good job on his appeal and his oral argument.
And you make the point in this book again and again, which happens to be called Illusion of Justice, that the legal system values finality of judgments over justice, which brings us to Steven Avery and where he is and what might happen to him next.
Right, and you know, a lot of people, they don't understand what the appeal system, how it's set up. They think, well, if the jury got it wrong, the appeals court will fix it. And that's absolutely not what happens. 95% of criminal appeals fail. 95%. So your chances are very, very slim once you've been convicted to begin with. Steven's case, his attorneys didn't go into the federal route. And some people ask, well, why didn't you represent Steven? Did it just, he ran out of money, so you stopped representing him? No, that had nothing to do with it. It's a quirk in Wisconsin law that it's not the case everywhere, but in Wisconsin, if a defendant wants to raise ineffective assistance of counsel, which they have every right to do, they have to do it in their first appeal in most instances. And so the trial attorney in Wisconsin never does the appeal, almost never. Because if I made a mistake, I'm human. If I missed something, the chances are I'm not going to see it on appeal either. And so the trial lawyers always step down and someone else takes over. But at any rate, his appellate lawyers didn't go into federal court, but he now has a new attorney who's been very successful with exonerations from the Chicago area. And one way that you can reopen an old case long afterwards is if you can find newly discovered evidence. And in the last 10 years, there's been quite a few advances in science that she's hopeful by retesting the evidence, she might come up with newly discovered evidence. Dean and I, once the documentary came out, between us we had probably 100 scientists from all over the world
calling you up,
writing us saying, there's all these different things you can do now. And the law moves very, very slowly, very like a glacier, but science moves very rapidly. So I'm still optimistic, and plus we had fact witnesses. Everything got turned over to his new attorney, Kathleen Zellner. People who came forward who, maybe initially thought, well, I thought this was something suspicious, but I didn't bother with it because it looked to me like they got the right guy. But now they realize that there's some uncertainty there. They came forward with some new information. So we'll see what happens.
Two more questions on the Avery case. One is, it sounds as if from reading your book that you thought this whole making a murderer idea was kind of weird and maybe a bad idea. But you came around eventually.
The documentary?
Yeah, participating in the documentary.
Yeah, no lawyer really likes the idea of a camera following them around. And, if I don't know about you, but even seeing myself in a home video, I always look weird. It's like, that's not me, But seeing yourself on TV and, 9 years younger is even weirder. But, we talked about it. And after meeting the filmmakers, they were film students, but they were like in their second career, so they were a little more sophisticated and mature than than you might otherwise think. And they had already gained the trust of Steven Avery. He wanted us to do it, wanted us to cooperate. He'd been through the system once before and been screwed, and so he had no fear of transparency. And we thought, there aren't very many cases, aren't many movies that really show what it's like to be a criminal defense attorney in real time. And so we thought it would be maybe a good public education campaign or an opportunity.
Imagine that.
Who knew, right? That it would be have this kind of an effect and this kind of a widespread audience.
Well, the messages, in part, that you try to convey, messages about the lack of independence, about forensic labs, the troubles of defending people with very little money and resources, the notion that prosecutors can engage in law enforcement can engage in extensive pre-trial and during trial publicity. All these things.
And it's shocking, and it's people after this documentary came out, they said, "This has got to be the weirdest case you've ever had in your career, right?" And I said, "Not quite." It's close, but at the same time, and I talk about this other case in depth in this book, case involving Ralph Armstrong, a guy who I fought for 15 years before I finally got him out after 29 years of being wrongly convicted. And it's like, it's in the book also because it was chronologically some of the same things were going on. And it's a long story, so I won't get into it in detail here, but in a nutshell, I had gotten DNA exclusions that were sufficient enough that the Wisconsin Supreme Court reversed his conviction and said the state either has to retry it or dismiss the case. And while the state was deciding whether to retry him, they were doing these other tests. And one of those, there was something like 60 more pieces of evidence, hairs and things at the scene, all of which excluded him. And one was a semen stain that was found on the murder weapon, a bathrobe belt that was draped across the woman's back, clearly handled by the perpetrator. The stain excluded my client and her fiance, and she wasn't known to have any other sexual partners. So clearly pointing to the perpetrator. I thought the case was going to be dismissed after that. Instead, they announced in court, we still intend to prosecute. We're convinced that Ralph Armstrong is guilty. And then I said, fine, then I want to be able to test this evidence. We have access. This was an Innocence Project case I was working with Barry Scheck on. We have access to the finest scientists in the world. The judge said, no problem. You can test this and see if you can develop the stain a little more clearly and figure out who the real perpetrator is. The next day or two, the prosecutor calls up his detective, sends them over, and they talk the clerk into releasing the bathrobe belt, sending it back to the crime lab for another test that destroyed the evidence. And the test that they picked was this bizarre, not a very strong test. It's called Y-DNA, YSTR, and it looks only at the male, the Y chromosome, and it's not as powerful as most DNA because everybody who's paternally related, father, brother, nephew, they all have the exact same Y DNA profile. So we had a court order that prevented this very thing that he did. And I said, why is he violating this court order, taking that kind of a chance for this kind of a weak test? In the middle of the Avery trial, I got a tip. The Avery trial was being streamed, court TV, live, all over the country and the world, and I would get emails every night, why don't you try asking this witness that? A lot of them were just kooky things. And in the middle I get this one that says, I see you also represent Ralph Armstrong. I have very important information for you. And luckily I didn't completely ignore it, but I was in the middle of trial, so I put it off for a couple of months. We got an investigator, looked into it. Turns out that Ralph Armstrong's brother had confessed to these two women that he was the killer, that his brother didn't understand that his brother was doing DNA tests, and that he was going to be excluded, and he was going to when he found out who he was going to come after him, the two women called. This was 13 years earlier. The two women called the prosecutor's office and spoke to the very same guy who prosecuted the case, and he never told a soul. And then he arranges to do a test that destroyed the evidence, using a test that would be that would be indistinguishable if in fact it was his brother.
His brother, yeah.
That to me looked like he was trying to frame his brother, or frame Armstrong with his brother's. And I was always suspicious of the brother for various reasons that we talk about in the book. But at any rate, ultimately all of this came out, and the prosecutor had to testify that, yeah, this happened, but nothing would convince him of Ralph Armstrong's innocence unless there was a videotape at the scene at the time of the murder showing somebody else doing it. This is the kind of mentality. And this prosecutor, in his defense, was otherwise a fairly reasonable guy. A guy who, nevertheless, you know, it's got to be hard for prosecutors when they bond with victims' families, and to then decades later have to come to them and say, "Sir, ma'am, I'm very sorry to tell you that we convicted the wrong guy, and the killer of your daughter got off." You know, that's got to be hard, but you still have to be able to do it. You know, you got to seek justice, not just convictions. And ultimately, the court threw out the conviction because of prosecutorial misconduct, but not until 29 years of this man's life had been taken.
Speaking of prosecutors who are not among your favorites, what's the nature of your ongoing relationship? If there is one, with Ken Kratz? And he's got his own book effort out.
He does. We don't exchange Christmas cards. You know, I don't communicate with Mr. Kratz. He doesn't communicate with me. He did just send me a tweet, direct message recently.
What did it say? What did it say, Jerry?
I'm not going to say.
Can you describe the general content?
No, that's okay. I won't do that. But, you know, he and I just never got along. That press conference.
You almost punched him out.
Well, there is a story in the book about that.
Yeah. That press conference, I'm sorry.
The press conference was so over the top outrageous that it destroyed my client's any chance he had of getting a fair trial. You know, it was being broadcast live in all 7 major media markets in the state of Wisconsin, and it was so outrageous and so graphic. I mean, it was really the best closing argument he ever gave in the case was the press conference. But of course there you could just make up facts because none of the evidence supported it. And it had such an effect on people in the state of Wisconsin that, you know, Wisconsin we abolished the death penalty in 1853. And we are the longest state continuously to not have the death penalty. And there's been efforts periodically to bring it back, and more recently in the last 30, 40 years, efforts to put like an advisory referendum on the ballot. And they all failed. Even after Jeffrey Dahmer, 20 bills failed. They could never even get it on the ballot as a referendum until Ken Kratz's press conference against Steven Avery. The bills were flooding the legislature, and not only did it manage to get on the ballot, but it passed 55% of Wisconsinites in favor of bringing back the death penalty, all because of the Ken Kratz press conference about Steven Avery. That was, you know, false evidence that was uncorroborated by any crime scene investigations. And so I frankly just find that unforgivable. I don't, you know, he's gotten a lot of stuff about his personal life. I don't fault him for that. He's human, you know, people do things, but that is, you know, what can you do to get Steven Avery's presumption of innocence back after that? So.
Yeah, it seems like a grudge worth holding. So with both Brendan and Steven still incarcerated, you you nonetheless offer some reasons for hope and reasons for action toward the end of your book, starting with actually showing up and voting.
Yeah, that would help. That would help, particularly, most, in every state, sheriffs are elected, and prosecutors, and in many states, judges. But they're most often on these sort of odd off-election or off-year elections or off cycle, so that they don't draw that many people. And it's often 15, 20% of turnout is what elects judges and prosecutors and sheriffs. And in fact, sheriffs and prosecutors are re-elected almost every time unopposed. A shocking number of times that there's never even a candidate against them. But that might be changing. Just this past year, big city prosecutors who had campaigned for years on the lock 'em up, throw away the key, the clanging cell door ads you see on TV, were defeated in Chicago, in Cleveland, in Jacksonville, Florida, and somewhere else. So people are finally starting to say, look, these old, tired, worn out policies aren't working. And you can make a difference if you get down there and to the ballot box and vote. If you just sit and do nothing. I mean, even our national election, Hillary, between the popular vote between Hillary and Trump, really the majority was apathy won that election because the majority of people didn't vote for either one of them. So, people do have to get out and vote. The other thing is, if you ever get a chance to be a juror, when you get that summons, most people look at it like it's a root canal. How do I get out of jury duty? But you really shouldn't do that. It's the one chance you have to directly participate in the judicial branch. And that doesn't mean that you should always try and get on a jury. There are some trials maybe that aren't right. You may have somebody, a close relative, who's been assaulted or sexually assaulted or something, and the facts as the judge describes them to you at the beginning may be too close to the heart that you can feel like you can't be fair. Then you're doing your duty by being honest about that too. But too often I see that people try and get out of jury duty, and you end up with either the very young students maybe or the retired people, and there's this big gap in the middle of peers that aren't there. So those are some things you can do right away to personally to try and make a difference in the future.
We are going to open up to questions. We have microphones on this side, and this side will alternate. So you, sir, then you, ma'am.
Thank you for your presentation and your book. My impression is that one of the significant reasons that some people don't vote is because they're trying to avoid jury duty. Is there some other system of selecting names for people to be sent to jury duty other than the voting rolls?
Yes, there are. In fact, different states have different methods. Some states, just because you avoid jury duty is not going to help you because they use driver's licenses.
Oh, really?
Oh, yeah. And some of them use whether you're a registered voter. Some of them don't. Even if you're not a registered voter, you may still end up on the jury list. So that's really going to vary from one place to the next, though.
Ma'am.
I'd like to follow further on the view of prosecutors, which I can understand you're on the other side, but I will confess that I'm an aficionado of the sort of true crime shows, and sometimes I just don't understand why the prosecutors are so aggressive, sometimes even if they're going to win. And I mean, they just, as you said, I don't know whether it's a scorecard thing. I don't know whether it's the personality of people who become prosecutors, but it's sort of no matter how much evidence you produce, I'm not going to change my mind. And also, I don't understand, I've seen instances where judges refuse on appeal to allow DNA test or something like that. I again, that just doesn't seem right. If there's a chance of innocence, okay, it costs money, but it's, the system does seem, to use a phrase, rigged.
Well, you bring up a good point with your last one about DNA tests, because the Wisconsin Supreme Court, which is really in disarray right now with a lot of controversy and a lot of infighting, just a day or two ago overturned precedent for at least the last 10, maybe 15 years, that under our post-conviction DNA statute, defendants could, if they agreed to pay for it, have pretty ready access to evidence to test for DNA. They now overturned that, and they now made it much more difficult for a defendant, even if he's willing or she's willing to pay for it, for no good reason, really, other than the argument, well, victims need some finality. They shouldn't, at some point we ought to be able to move on.
But, I mean, new evidence, okay.
But, but in terms of prosecutors, I mean, look, most prosecutors are not like the guy I just described. Most prosecutors try and do the right thing. They're taught that, they're under the rules of ethics. They're not just supposed to seek a conviction. They're supposed to seek justice. But we have a system that too often encourages just the opposite. So I'll give you an example, right from the Avery case. A lot of people have written about how is it that the state was able to argue in Avery's case that there was no murder in the bedroom. That's why there was no blood in the bedroom. The murder happened in the garage. And yet, a month later, in Brendan Dassey's case, they argued just the opposite. And the whole thing was, well, this murder happened in the bedroom because that was the story that they coerced out of him, basically. And people, would say, that can't be right. That can't be fair. How is that allowed? Well, unfortunately, American courts generally do allow it, and they shouldn't allow it, because if a trial is supposed to be the search for the truth, and you've got one crime and two different defendants, and the prosecutors are arguing two irreconcilable theories of guilt, then necessarily at least one of those trials is not a search for the truth. It's a search for a conviction, and that's all they're trying to do. So there's some things we can do to rein in prosecutors and to discourage that kind of behavior and get them back to trying to do justice rather than just seek a conviction.
I'd like to thank you for your laudable efforts in defending the undefended, and also the fact that you mentioned about your privilege and your middle class status and the fact that you're a white male. But what I would like to shift and talk about a little bit is about the Fifth Amendment in reference to minor traffic stops. I recently purchased a book entitled A Toast to Silence by Peter Baskin, a trial lawyer from West Virginia, in which he talked about the Fifth Amendment and what you should do for minor traffic stops. And for a long time, I thought you had to answer the police when they ask a question. I think most people do. And so the media and many lawyers also perpetuate this myth that somehow when the police stop you and they ask you a question, that somehow you have to answer. You really don't. All you have to say is, I have nothing to say, and I request a lawyer. Of course, in the book, he said demand, but I wouldn't use that word. So what I want for you
Name,
to,
rank, and serial number. That's
right. But what I would like for you to do is to focus on the Fifth Amendment and why is it that it is not explained that when the police stop you and they ask you a question, you really don't have to say anything at all except identify yourself.
Well, that's a good point. And in fact, the police are, most police, again, are, trying to protect and serve. They're not just out to try and convict innocent people or harass people. But some of them are. We know that. And, if you've ever had encountered a cop who's got an attitude, who hasn't at some point or another? Yeah, if you try and push back at all, they can get pretty nasty, and so they, I think, use that and their sense of authority to get people to cooperate. Unfortunately, the courts say that you don't have to be told unless you're in a custodial setting, or not. In other words, unless you are in custody, which they define as a situation where a reasonable person would think they were not free to leave, then they don't have to read you your Miranda rights and to warn you that you don't have to say anything and that you can remain silent. But it goes even beyond that. We were talking before the event started tonight about Illinois has just passed a law that that prohibits the police from interviewing in a custodial setting anybody 15 or younger. They were trying to get it at 17, so it would be all minors, but they had to compromise at 15. But along with that bill is this really kind of interesting additional provision, which is there's been studies that have shown that Miranda, even though you hear it over and over on TV, you have a right to remain silent, anything you say can be used against you, etc. A lot of particularly juvenile or teenage defendants don't really understand the concepts. They may be 15, 16, 17 chronologically, but when it comes to their reading and comprehension levels, they may be more like 9 or 10. And when they've done studies, they don't really understand the concepts behind your right to remain silent and your right not to say, to cooperate with the police. And so this law in Illinois now has required that they rewrite the Miranda rules in a way that make it simpler for particularly juvenile defendants to understand. But some of that, now there's an example where that's coming from the legislature, not from the courts. The courts have been slow to expand people's rights when it comes to the Fifth Amendment. But if individuals are unhappy with the way police are abusing those rights, then they need to get a groundswell of grassroots movement to try and get their legislatures to change things like they did in Illinois. That proves it can be done. You just need to be organized enough to do it.
Hi, you touched on science a little bit already, but I was wondering if you could speak a little bit more about the role you've seen science and the expert witness play over time with your career, because I know you see like the public defender's office is a great public service, but then you also see the private defense attorneys who make huge sums of money, and then you see these expert witnesses that kind of come in and they have the credentials that can get them that money, but then on the other side, for a public defender, you can't necessarily provide that to counterbalance that.
Yeah, science in the courtroom that's a big thing for me. That's been one of sort of my niche practices. And the reality is that science is in the courtroom, and it's not going away. It's very difficult to defend a case now without resources for science, for forensic science. Unfortunately, it's not just a question of having resources. Unfortunately, it's also a question of what we allow. And a lot of quote-unquote forensic science has really been proven to be junk science. It was never validated to begin with. It was used in court and continues to be used, some of it, way too readily, and jurors accept it way too readily. So, for example, microscopic hair comparison. For decades, it's where you basically you find a hair at the scene of the crime, and then you pluck a hair from the defendant, and you put a dual microscope, and you you're just eyeballing it, and you're looking at the color and the thickness and these various sort of ill-defined features, and then an expert comes into court and testifies that the defendant's hair is consistent with or similar to this crime scene hair. Well, the FBI just did a study retrospectively, went back and looked at 269 of their own cases involving their own experts. I think it was maybe 28 different experts. And they, to their credit, the FBI came forward and admitted that something like 95% of their own experts had either falsely testified about what they could really determine or misleadingly testified in a way that helped the prosecution. And now the FBI is in, at least before our new administration, the FBI was involved in working with NACDL, and I think they still will.
National Association of Criminal Defense Lawyers.
To go back and look at some of these convictions and see whether that kind of testimony would have made a difference. Unfortunately, that's the tip of the iceberg. Something like 90% of all crimes, prosecutions are at the state level. And forensic scientists all over the country in crime labs were trained by these people at the FBI about that. There's other things, bite mark evidence that's now been debunked. Tool mark evidence and so-called ballistics evidence is the next to fall, I predict. There's already been a lot of challenges about it. So part of the problem is that we don't have real science in the courtroom, but part of it is it's how do you show that if you're a public defender, and all you can afford is maybe nobody except cross-examining the state's expert, who is dead set that his or her opinion is the gospel truth. That's why, resources, it's not just hiring good lawyers. It also, you have to have enough resources for the indigent, for investigation and experts. It's become essential. In fact, even the Supreme Court years ago in Ake versus Oklahoma said that it's gotten to the point where a defendant has a right to have, and that was an insanity case, at state expense, not just a lawyer, but also an expert.
So we are out of time. We can take one more question. I think, sir, you've been standing for a long time, and if the others wouldn't mind asking during the signing, that'd be great.
Yeah, I was just curious what you think if anything, the documentary Making a Murderer got wrong, and also if what's been maybe the most surreal experience for you, since I can't imagine you expected the documentary to be as big as it's gotten.
Boy, the surreal experiences would take the rest of the night. But in terms of what the documentary got wrong, I mean, Mr. Kratz, right after the documentary came out, sort of started a campaign against the filmmakers, and he continues it in his book and in interviews, in which he says that the documentary is biased. It leaves out all this powerful prosecution evidence, and he has sort of a laundry list of things that were not in the documentary, some of which were never in the trial either, because the judge looked at it and said it wasn't probative enough, it wasn't relevant enough to even allow it to come into trial. But the other parts, I don't know the decisions they made and why they made them. We didn't have any kind of editorial control. If we did, I would never have allowed that scene where I'm all giddy about the blood vial and look like a dork with my flip phone. But he, what I think they did, though, was when it comes to the evidence that the parties really fought the most over, and you can tell that by the amount of time we spent in our closing arguments. The major points are covered and both sides are presented. That's the blood, the bones, the bullet, the key, magical key that's found in the bedroom. There's a lot of coverage of that in the documentary, and those were the main things that prosecution and defense were arguing. Some of the things that he wants to bring up, you know, the sweat DNA on the hood latch, if you've seen the comment about that. He spent, I went back and looked, he spent a half a page in his closing argument out of hundreds of pages talking about that one thing, because as the evidence came out at the trial, it was debunked as like a red herring. It was pretty clear that it was just as likely an innocent transfer by their own analyst who forgot to change gloves when he went from the inside of the car to open up the hood. So, it was a 6-week trial. They had to make editorial decisions. And I don't fault them for that. They left out some defense evidence that I would have liked to see. But I think the one thing that you do get, you do get more of a flavor of the defense, probably because we cooperated. There's some behind-the-scenes interviews with us, brainstorming sessions and things like that. But the prosecution was given the same opportunity. And in fact, I thought that at one point they were going to. The police did get interviewed. And then when it came to the point where you have to sign away your soul, to the release to allow your image to be disseminated and whatnot, they refused to do that. So it's unfair, I think, to the filmmakers for them to now complain about how one-sided it is when they were given the chance to participate and chose not to. I wish they had. I think it would have been interesting to see. I've never really seen a real documentary not some TV thing, that shows them preparing behind the scenes and brainstorming, how are we going to present this evidence and what are we going to do with this defense witness. And that would have been useful and educational too, but they chose not to.
Thank you so much, Jerry. Appreciate it.
You're welcome. Thanks for coming.